It is.
It's for any age.
It really is. It's
really
so awesome.
I love
And
it.
do you watch the show now?
No.
They have like a behind the scenes show on Animal Planet.
Oh, really?
So cool.
I
All right, good morning. We're going to get started. I have about 10:15 on my. Yes, I do. I have 10:15 on my phone. So we're going to get started. Thank you. Good morning. My name is Peter Farreau. And for those of you who didn't notice, we're in the ethics session. So hopefully everyone's here for ethics. And, you know, the subtitle really is Beyond Gifts and Fruit Baskets. I think we're going to try to move beyond, you know, if someone sends you a fruit basket, what should you do in the office? We're going to move beyond that to something a little more difficult maybe, but engaging. And one of the things I would mention is we're going to ask for a lot of audience participation. Without it, it's us talking for an hour and a half, and that's not going to be as interesting. We have a microphone here for folks that want to be heard. They're videotaping the session to post on the Planning Federation's website. So it would be great if you can pick up the mic and make your comments, ask your questions. If not, we'll repeat them from up here, obviously, but that would help. So again, my name is Peter Farreau. I'm here with Dan Rizzo and Lisa Nagel, who are going to introduce themselves when they get up, and just really briefly run through the agenda for this morning. The first thing we're going to cover is ethics and conflicts of interest for municipal officials when that stops blinking. Okay. No. Yeah. This guy, he looks okay. Okay. So the first thing we're going to cover is ethics and conflicts of interest for municipal officials. And then we're going to move on to ethical requirements for professional planners, those who are AICP certified. We're going to have a focused discussion, some case studies, and then some more audience discussion. But before we get started, just by a show of hands, how many folks here sit on a municipal board, planning board, zoning board, architecture review board? Yes. Okay, so that's about 95% of you. How many folks here are AICP certified planners? Okay. How many are both? Oh, good. All right, good. So then our case studies are going to be great. Okay, so for those who didn't see, we have mostly municipal officials sitting on boards. We have a handful of professional planners who seem to be along that wall over there. So that's okay. And so we're going to gear that discussion accordingly. So I'm gonna sit down. I'm gonna hand it off to Dan, who can take you the rest of the way.
Good morning. My name is Dan Russo. I'm with Whiteman, Osterman, and Hanna in Albany, New York. I've had the privilege of being on the board of the Planning Federation for a dozen years. It's actually a while ago already. And as Mark Schachner spoke this morning about, and I'll refer you to a couple of things that Mark said during the course of my comments, but that I think one of my first presentations was in 1981 at the Planning Board Federation, I think at the meeting in the Nevele, of all places, if you remember that. But it goes back a while. I did have the privilege of being on the Clifton Park Town Ethics Board back in the early 90s. Ethics is sort of my life now because I'm the general counsel to Whiteman, Osterman, and Hanna. And most of the work I do for the firm has to do with ethics and conflict issues among lawyers. So it's a topic that is near and dear to my heart. Today we're going to talk, at least in my presentation, we're going to talk a little bit about the general municipal law provisions in parts sections 800 through 812. We're not so much from a pure legal point of view, just so you understand what the basic rules are that govern it. We're also going to talk a little bit about local codes of ethics, because in most towns there is a local code of ethics. Raise your hand if you're familiar with your town's codes of ethics. Are there any towns that or villages, et cetera, that don't have a code of ethics that you're aware of? Okay. And then the last, I'll just talk about some principles that have come through what we call common law, case law in New York. But we start with 801 of the General Municipal Law, and it deals with conflicts of interest that have to do with the individual officer or employee and the municipality they work for. And so the premise for this is, and it may not apply to many of you in your official positions, but you need to be aware of it, because as an officer of the municipality, as an appointed officer, a member of a planning board, you can't have, there's certain restrictions that violation of which are misdemeanors, and so you can't have an interest in a contract where you are the beneficiary, if you will, of the contract, if you have some measure of control over the entering into that contract. And there are definitions of what an interest is. An interest is primarily pecuniary interest. It doesn't really apply to most planning board circumstances, so we're going to skip. The next, again, it defined, these are just definitions straight out of the 801, dealing with what is a municipal officer. You'll see whether paid or unpaid, so obviously the volunteer positions in most municipalities for planning and zoning officials would apply, and including members of any admission. So you're a municipal officer or employee by virtue of your appointment. And a contract is defined. There's a reference to a state controller opinion that said that a zoning change is not a contract, but issuance of a building permit may be. The whole point of this is you need to sort of pay attention to the matters that come before you and any connection you might have on a personal level to them. Conflicts of interest, again, prohibited. It's not just you, though. It's you and your family. And so in 801, it defines that you have an interest as an individual in a contract that your spouse, minor children, and dependents might have, a firm or partnership of which one of those individuals, including yourself, may be a member, a corporation in which you're an officer, et cetera. So it's a broad net to try to avoid appearance and actual conflicts of interest in some fashion before the municipality. Then there's some 15 exemptions from the law, and that's in 802. And that's where it's solely because of your position where you actually just get paid, but you don't affect the decision-making by the entity that employs you. And then designating a newspaper, if you have some connection with a newspaper or a family member works for a newspaper, that is an exemption for this. So if you have to require someone to publish notice in the official town newspaper, that's not a conflict. If you have investments as either municipal stock, through stocks or mutual funds, et cetera, but you're not a 5% or greater owner, then you're exempt. So you don't have to worry about that aspect of it. And again, these are exemptions. These are all statutory exemptions from when you might have a conflict as an officer in a municipality. Again, not all that relevant to most of what the zoning and planning does, but this summarizes sort of the 5-step process that you go through to determine whether or not you have an interest in something that is coming before you. And If none of the, if an exemption applies or you don't meet those standards, you may still have some interest in something that for which disclosure under 803 of the rules would require. But again, this is sort of background information so you understand where this is coming from. The next, disclosure of interest. 803 is one of, it's sort of an appearance of impropriety. In today's world, transparency is the magic word. You want people to know if you have some connection with something that may come before you. So you need to be prepared to disclose the extent, publicly disclose it, the extent of any connection that you may have, and it becomes part of the record. It's important. It's part of the administrative record that is important to create in any application, so that someone down the road can't accuse you of having an interest that you failed to disclose. And it's a defensive thing in today's world. Mark Schachner spoke a little bit about how tension-filled planning and zoning can become. This is important to protect you. You have an obligation to disclose things that if you have a connection with, and in some cases, recuse yourself from actually voting on something if it's so close or it's more than a de minimis interest that you may have. And we'll give some examples of these things later, but you know, and take questions as well. In 806 of the code is a provision that directs the municipality and all municipalities to adopt a local code of ethics. And section 800 through 812 is in the state law, the general municipal law, is the minimum standards. Remember, Mark talked a little bit this morning about legal requirements and then other things. All right, the code that a local municipality is authorized to enact and required to enact is something that provides additional requirements. It can repeat some of the language that's in the 800 sections of the general municipal law, but there tends to be additional requirements, and I'll give you some examples of that in a little while. In addition, there is in section 808 of the code is the authority for a board of ethics to be appointed by the town board or village board, city board, municipal council, to basically oversee and to be a resource for gaining answers to ethical questions that may arise. And it's one of those things, as I said, I had the privilege of chairing, I believe, the Clifton Park Board of Ethics back in the early 90s. And we were a resource for board members. The last thing you really want to have happen is for someone to feel so abused or somehow affected to go to court to sue the town or whatever regarding somebody's activities. The board provides sort of a guidance and a buffer for the municipality, and it's a very important function. I think it's underused, quite frankly, particularly in today's world, but it's a resource. Local ethics laws. As I said, there is basically a blank sheet of paper for local municipalities to create their own ethics rules that are meaningful for them. It's one of those things that the creation of local ethics laws, though, need to be thoughtful and to meet the needs of the community. You need to avoid, or the towns need to avoid, just adopting something from somebody else without any consideration of how it fits into your community. These are provisions, and we can, wait, you're going to come back? There we go. These are provisions, I don't know, Mark, technical folks, that come from a local capital district town, and they're quite strident in their requirements. They have no this is sort of normal, but and maybe for most of you, it would be, for anyone who's been in state service or in other governmental service in the past, some of these will be familiar to you because the Public Officers Law has similar provisions. But you're not allowed to ask for employment opportunity from somebody who is appearing before you. While the matter is pending, or in this case, in the way this town did it, within a year following the disposition of the matter. And then there's the second one is for a 2-year period after serving as an officer, you're not able to render services to a private person involving a matter in which that had come before you. And then another provision, the last provision, that deals with representing a person in a particular transaction that was before you. As I said, those are, I don't know if this is going to be, maybe that'll behave itself. Some other examples. No town officer requires, and let me just skip ahead for a minute. Let me see, go back. It's surging, yeah. Let me go to this for a minute. This is the gift provision. We said that we was going to go beyond gifts. Yeah, we are, but we have to talk about gifts. This is 805A, which basically says you can't accept gifts or material things, services, et cetera, in excess of $75 or over $75 in value, if it's reasonably inferred that it's being given to you to thank you for influence your decision making. And remember the B down here, disclose confidential information. I'm gonna come back to that in a minute. No town. This is the local ethics code that mirrors a little bit what is in the general municipal law. So let's talk about confidential information for a moment. And this is also ethical related issues. You often can receive confidential information in an application, and under the Freedom of Information Act, Information Law, that can be designated and kept confidential. There's also confidential information that may come up in an executive session. The reason that if you're in a legitimate executive session, there's confidential information. That information is supposed to remain confidential. And confidential information you may receive about an application is not to be used for your personal benefit, but it also is not supposed to be disclosed generally. This provision of local ethics law reminds people of that. And there's an appellate division decision, mid-level courts in New York, that have basically directed that or authorized, confirmed, that confidential information can be required to be kept confidential, and the local code can direct officers and employees to keep it confidential as a matter of ethics law. In addition, so that's the confidential information provision. Also, another example in the local code provisions are the repeating of gifts, that the gift prohibition that is in the general municipal law. In the example that in the local code, it talks about aggregating gifts of up to over $100. And again, the idea is, look, we don't want people we don't want applicants rewarding board members for any reason, number one. And number two is it undermines the trust that the public has in the system of decision making at a local level when they believe someone is seeking favors and does it through monetary basis. All right, I think we have talked about that gift giving as well. So the consequences of violating the things we've been talking about so far, which is sections 801 through 805, is a misdemeanor, which is a crime in New York. It rarely occurs. When it occurs, you have probably read about it in the newspaper, because it receives a great deal of public attention. With respect to the contract reference that I made earlier, in section 801, violating that is obviously a misdemeanor, but the contract itself is null and void. And a court can basically knock out that contract because of an action by a municipal official getting a benefit. All right, we've talked about that. Other examples. I put in the slides a collection of Attorney General's opinions and State Controller opinions that I thought were particularly relevant to zoning and planning officials' actions. And the first is that donations received by a municipal officer to pay legal fees incurred in pursuing a court proceeding against another city official are gifts in violation of the restrictions of 805A. Another example, and this may hit home a little closer, a town planning board member who is also a geologist in the private sector may not be compensated or enter into an agreement to be compensated for soil borings on a project before the planning board. That should be pretty obvious to everybody, but it obviously wasn't obvious to one person. But they sought an opinion, and that's the right thing to do. The chair of a planning board is employed by a real estate company that would receive business if a subdivision application is approved, should not participate in the consideration of the application. This is an old Attorney General's opinion from '86, and again, there was a clear nexus in the facts between the work that the real estate broker was doing and the subdivisions that were appearing before him in a small town. Another example is a licensed architect who sits on a ZBA should not represent persons making their initial application before the local building department. Why? Because the ZBA has authority to review the actions of the building department, and it created too much of an appearance of impropriety. Another example, a member of a city council must avoid circumstances in which may compromise their ability to make decisions solely in the public interest. If his or her employer are affected by matters before the council, recusal is the appropriate course of action. And this is a 1997 opinion of the Attorney General, but it builds on a whole host of court decisions revolving around, and some of you may know the case of Tuxedo taxpayers, and another older case, Zarekin versus in Orange County, where members of Orange and Rockland Utility were sat on the boards, the local town and village boards, and there were applications of O&R coming into the fore, and they said, look, as a matter of common law, state common law, you have to recuse yourself. You can't be passing on things that are tied to what your employer needs. Go ahead, sure. Another example, an architect is a member of the Village Design Review Commission, doesn't need to resign, but may recuse himself when his firm is involved in a project before the commission. The reason for that holding was that it was a very rare occurrence. If it was a regular occurrence, the person probably couldn't serve. But because it was an infrequent circumstance, he'd simply recuse himself if the matter came before. Another example, a local legislative body by code or in its code of ethics has the statutory authority to prohibit a legislator from disclosing matters discussed in executive session. And there's another court decision that reaffirms that. Look, if you want people to take the confidentiality of the executive sessions seriously, then here. Then it's important for the municipality to adopt a code that makes it very clear. And the reason is not to punish somebody, it's just to remind people you shouldn't be talking about things that are supposedly confidential in a public forum. A planning board member, I think maybe this next one, there we are. A planning board member is prohibited from receiving any compensation for engineering services performed in connection with the matter that comes before the board. Even if the services are unpaid, recusal is warranted. Again, this is the idea is it's more than just your pecuniary benefit. It has to do with the appearance of how that behavior looks in terms of the fairness of the proceedings. Planning board's personal attorney, this is an interesting one, appears before, it goes to disclosure, the importance of disclosing potential conflicts, even if you don't have a direct sort of hand in a game. If you have a close relationship with a lawyer and that lawyer is appearing before the board on a matter for an applicant, you probably don't have to recuse yourself, but you ought to tell people, yes, I know that individual. It goes to the point that Mark made earlier about the manner in which you communicate or introduce people or talk to people as a board member. If you keep it more formal, everybody feels more comfortable than if some people are treated as Joe and Hal and Sue and others are not. A village board member who has a financial interest in a business that be negatively affected by a zone change should probably disclose that interest, and if it's more than a de minimis effect, probably recuse themselves. But that's a board member, and that's again important for keeping the sanctity of the whole system. And now this last slide is deals with disclosure. All applications are required before boards, et cetera, are required to disclose whether anyone has an interest in it. And there's a form that most towns use and villages use now that needs to be completed as part of the application for an approval of some kind. And the importance of it is these are obligations of an applicant, but one of the things that a board member has to be conscious of is remembering that if it's a child or a relative, a close relative has it, and you are aware of it, and even if the form isn't complete, they don't know that somebody else is related to you, and they fail to do it, fail to identify it in the form, you have an obligation in your meetings to identify that connection, and again, if it's a close one and there's a financial interest to be gained, then you may have to recuse yourself. But at a minimum, it needs to be disclosed. And with that, I will leave it to you guys. Good luck.
I'm tempted to just stay seated, but that's okay. So, ethical standards for AICP planners. So, what we're going to go through really quickly are some of the standards that are required of professional planners who hold a certification from the American Planning Association called the AICP. And the reason we're going to go through this, well, there are two reasons. One, there are AICP planners here, myself included, who need our credits. But the other reason is they're really broad principles and broad rules, and they really do apply to everyone acting in the planning process. In fact, towards the end of end of this section, you'll see that the American Planning Association has adopted principles, that are recommended principles for all actors in the planning process, including municipal officials. So why should we talk about this in general? And maybe we should have done this up front, but this is something specific that the APA kind of requires us to say. But it's obvious, right? Citizens have a right to expect that people acting in the planning process will elevate governance, that we're going to treat other professionals fairly, that we're going to treat our communities fairly, that what happens in the planning process is not about the applicant, but the application. A lot of this is common sense. Not all of it, however, is common sense, and so it's worth talking about it and getting into these discussions which we will do very soon because that's where the most value comes, is in talking about these situations where it is a little more nuanced, it's not cut and dried, and what we really need to do is figure out approaches to how we deal with this. So for those AICP planners in the room, please note, this session has been created to provide general education regarding the AICP Code of Ethics, and yes, I do have to say this. Though example, sample problems, and question and answer sessions are important, only the ethics officer of the American Planning Association is authorized to give formal advice on the propriety of an AICP planner's proposed conduct. And as we're going to get into a little bit later, anyone can call the AICP ethics officer, can email the AICP ethics officer with questions about an AICP planner's ethical responsibilities. And this is important for municipal officials as well, because chances are you will have AICP certified professional planners at some point coming before your board. So the Code of Ethics for the AICP is broken up into a couple sections. The first are these aspirational ideals. Then there are rules of conduct and advisory opinions. So we're going to start with the aspirational principles. So these aspirational principles are really the ideals. And the first one is that our primary focus is to serve the public interest. This kind of goes without saying, but it's interesting when you drill down into it. And for those of you who are interested, the American Planning Association posts its Code of Ethics on its website. But some of the principles under this first heading are that planners and those in the planning process should be thinking about the long-range consequences and the interrelatedness of their decisions. That's what people expect of us in the planning world. What is also interested in here is that this principle that we shall give people the opportunity to have a meaningful impact on the development of plans and programs that may affect them. It's not enough just to provide for lip service. Our aspirational ideal is that we provide the opportunity for meaningful input, that the public has a say in the development and in the plans for their community, and that we treat all participants in this process fairly and equally. And that goes back to what Mark was saying of elevating the dialogue and promoting respect and civility. AICP planners also owe our clients and our communities and the public diligent, creative, competent performance. That performance has to be consistent with our first charge, which is to serve the public interest. We can have disagreements. We should serve our clients, but our goal is to serve our clients for the purpose of elevating the public interest. And finally, we should talk about planning. We should talk about what we do. We should talk about how we do it. We should talk about why it's important. When the public understands more about the planning process, why we plan, why we have applications, why we have these rules, and what the benefits are to the community, they're more engaged. We get better results and better buy-in. So the next sections of the AICP Code of Ethics really go into the rules of conduct and then a lot of procedures, and like any good professional organization, unfortunately the rules are the most important thing, and there are 2 pages of this code, and the next 6 are dealing with process. So we're going to go over the rules of conduct, and I'm going to turn it over to Lisa to start with, and just keep in mind while these are for professional planners, they really are principles to which kind of we all would aspire.
Trusting this works.
Well, we're going to try.
Thanks, Peter. So my name's Lisa Nagel, and I'm with Elan Planning and Design right in Saratoga Springs, New York. We work around the state doing a lot of comprehensive planning, a lot of zoning work, design guidelines, a lot of brownfield redevelopment, and so the rules of conduct and a lot of what Mark was talking about in the context of planning board members really apply to us as professional planners as well, dealing with folks in public meetings in that. So as Peter said, he went over the aspirational principles, and we want to cover pretty quickly. We'll take a little bit of time on the rules of conduct. But then we'll go over some procedural elements as well. And then we have some sort of example case, real-life case studies, protect the innocent with the names to go through. But really, the rules of conduct are exactly what Mark was saying, is that they're really written to serve in the public interest, with compassion, in the welfare of the community at large, and with integrity. So this really applies whether you're AICP planner or sitting on a planning board. I just sit down, or right. So the rules of conduct, there are actually 26 of them. We're not going to go through all 26 of them, thankfully. Well, 20 through 26 are more like sort of process, so really there's 20. These are enforced by the American Institute of Certified Planners, by the Institute. If they aren't abided by, or if you're reported to the ethics officer, as Peter pointed out earlier, you can lose your certification. But again, these are sort of good rules in terms of planning. Providing, we'll skip over these in some quick fashion so we can get to the case studies, but providing adequate, timely, clear, and accurate information, that's part of the integrity. Shall not publicly advocate for a position adverse to a previously advocated position within 3 years without disclosure, and there are a few exceptions to that, and that really ties in. When we get to the case studies, we asked Dan to provide the GML equivalent of the AICP. And so this is one that the three of us preparing talked about at some length. Another one, need permission from employer if you are seeking a second planning job, even if you're not paid. There are also exceptions to that if there's a rule in your current employer's sort of rule book, if you will, that has that. The next one is interesting, that public employees, officials shall not receive any compensation or advantage. Dan talked about this as well, but we italicized perceived as related to our service. So even if it's a perception, you're best to not take any of that compensation, disclose all the information, as Mark talked about this morning, as Dan reiterated. That perception piece is a key one. Did you want anything more about that? Shall not work for a client if there's a personal interest without the consent of the client. This is really about personal financial gain, is what that's saying, and speak. And you know what? I give a lot of credit to Peter, because he took these 26 rules and made the double negatives into something that's understandable. So he did a great job. And then shall hold information as confidential with our clients or through the planning process. The exception there is required by law, right? If there's some legal matter that Dan or Mark Schechner's of the world would tell us otherwise, we may have to disclose that information. All right. The ex parte communications is prohibited. And then, I just want to read my note. This, again, I think Mark was talking about the example in the grocery store. Like, somebody comes up to you, talks in the grocery store, you go back and you disclose that information to your board. And then this, yeah.
So one thing I just want to say on that, the AICP actually has 2 rules on that. And one of them is the public officials or employees should not engage in the private communications if it's prohibited by law, agency rules, procedures, or custom. So if it's not something that you normally do, you shouldn't do it. You shouldn't make the exceptions. And why is that important for those of you who aren't AICP planners? Because the AICP planners in the room shouldn't be looking to do that. They should not be asking you to have those communications. And it's really important that like Mark said, where there is a rule, you follow it. And where there's not a rule, it might be a good idea to develop one so that you don't run into these dicey situations of, well, it's not prohibited by law, but is it really prohibited by custom? I wouldn't want to be in the position where I have to defend what the custom is. I would rather be in a position where I say, this is the rule for how we have these communications, whether it's in a private work session, at a site visit, or something else. So it's really good to kind of establish those boundaries up front. Sorry.
No, that's good.
I love that one.
And it goes to transparency too, right? It's that discussion too. Should not misstate your educational qualifications or misrepresent the views of other professionals. There's a whole host of this is actually 10 through 15 out of the 26 about really just, having your own credentials, working on your own credentials, working on your own merit, and not misstating anything to seek a job, to win a job, to influence someone, et cetera, et cetera. So it's really acting on your own qualifications and not those of others. Shall not accept work beyond professional competency. Again, very similar. I think this goes back to the qualifications of who you are. And then if you can't complete it on time as necessary by a client. Again, if you're on a plan, I think it goes to the planning board. If you're hiring a professional planner to help review, say, a major project, I always remind planning boards of this, that you often have your legal counsel at the table, often the TDE, town designated engineers at the table. If it's a major project and can have a major implication in your community on quality of life or any other aspect, you can have a professional planner at the planning board table too. You just need to make sure that professional planner is working within their qualifications and has the time to review and help you. Shall not use the work products of others. I think we talked about this. Shall not direct or coerce professionals to reach findings not supported by available evidence. Of course, again, transparency, qualifications, the integrity of the profession. We should be working on the research that we have available to us to help make decisions. And that goes to, if a professional planner, again, is helping a planning board. And then, there we go. Must disclose interests of the client or employer when participating in the planning process. Again, this is disclosure, working, and transparency, working with the boards. There's a whole host of other rules of conduct which are really on the behavior when charges of misconduct are made. So we don't have those here on this slideshow today. But if you're in seeking your ethics, I would take a look at those on the planning website.
So, like I said before, any person can seek an advisory opinion from the APA's ethics officer. You can do it via phone. They don't prefer it via email because they just view it as so not secure in terms of sharing personal information. They really don't want to be responsible for having personal information sent on an email. But you can seek a formal opinion in writing. And you can use that if you get that opinion proactively as a defense against a future ethics charge. And something new, and I think this is really good, and I'm hopeful that the AICP does this a little more often, because I think it would be very helpful to everyone in the planning process. They can issue advisory opinions without a formal request. They never thought they had that authority, and they somehow thought they had to give themselves that authority, and they did, so I'm glad they did. But this is really important, so they can really flesh out these rules, because they are not as clear-cut as they could be. Yeah.
On that too, Peter, on the rules, so for those of you who aren't professional planners in the room, there is the American Planning Association has their website, which is just planning.org, O-R-G. And then there's a whole tab on ethics, and so these advisory opinions get posted. The cases from the previous years are all documented and posted, because it isn't clear cut. So these opinions have been valuable. So if you have an interest or a curiosity, or you're thinking through something that happened in your community, you can go to planning.org, and all this information is there.
Right, and so anyone can file a complaint against a professional planner. Hopefully, no one ever has to, but every year there's about, 50 or 60 complaints that are filed. About a third of them are related to conflicts of interest. I know there was a question, please.
One before that, can we're not members of this organization, planning board members, but can we request an opinion from someone?
So you could request an opinion if it has to do with the conduct of a professional planner. If it has to do with the conduct of your board, then you'd want to seek an opinion from the Attorney General or the Controller.
Or your local.
Or your local,
ethics, board.
right. These are more process, so I'm gonna move on. So, as I said at the beginning, we're about to get into the better part of this conversation where we're not lecturing. The American Planning Association adopted ethical principles for participants in the planning process. Obviously, these are not binding, but these are kind of best practices, and I think they sound familiar, right? That we serve the public interest. We put out information and we provide accurate information. So Mark talked a lot about the Freedom of Information Law. Should the applications be public? When are they public? How quickly? I mean, obviously best practices, as much of that information as we can make available publicly as soon as it comes in, we should. It's not our information. It's not proprietary. It's not something that we need to keep secret. And by putting out this information, we're advancing kind of public trust in the process and transparency. And we're really promoting this idea that we're serving the public interest. Maintain high standards of integrity and proficiency. I think that's kind of pretty self-evident. And this last one I find really interesting, which is that we need to constantly improve our professional competence. And this is something that I think, you know, again, it's like preaching to the choir. You wouldn't be here if that isn't what you were seeking to do. But I think it's really important that we continue to have these conversations and these dialogues to talk about these issues, because that's how we continue to improve as public servants. So now we're going to get to the case studies, and this is where we're going to ask for your active participation, because without it, it really will be boring, more boring than this, and no one wants that. So there's a microphone up front. You can get it and switch it on, and then your voice will be held for posterity by the Planning Federation, or you can just shout and we'll repeat your question, comment from up here. But the goal is to engage in a dialogue. So what we're going to do now is just go through a couple case studies and ask for your feedback on them, and then we're going to open it up to some more topics, questions that you guys have if you have questions that you'd like to talk about or a scenario. So the first is employee ownership, public service. And this was adapted from an actual case from the American Planning Association. We've kind of massaged it a little to fit, but this actually happened. So Patrick is a planning consultant that lives in the town of Gettysville, where his firm provides planning services through contract, but Patrick doesn't work on Gettysville projects. Doesn't want to work in his own backyard. I get it. Patrick has been offered a position on his town's planning board because he's such a good planner and really involved in his community. But Patrick really doesn't want to leave his firm. He likes his firm, he likes his salary, he wants to put his kids through college, and so he's kind of torn. He doesn't work for Gettysville on Gettysville contract, but his firm does. So what should Patrick be thinking about? Should he accept the appointment? What are the implications for his firm's contract? And would anything be different if Patrick were elected to the town board rather than appointed to a planning board? And so what we've listed is a couple of the principles that we think are relevant here, as well as some of the GML provisions. So I'm curious to open it up from the audience, what you guys think about what Patrick should do.
The first question? What about the first question?
Come on, someone's got to have an opinion about
Should-
Patrick.
So she
Is he that good that he has to stay with it? He can't do anything else? I mean, what? No one?
planners?
Come on. You don't want to hear me speak for the next 45 minutes. So one of the things is that Patrick needs to be cognizant of as a professional planner is that he needs the permission of his employer to take on another planning related job. But I think the most important thing is that public officials are not supposed to receive any special advantage that's not in the public record and not in the public interest. So technically, could Patrick serve? Probably, yeah, he probably could as an AICP planner. Would that violate his AICP code of ethics? Probably not. Would he need to disclose that? Yes, he would need to disclose that. He might need to disclose that at every meeting as part of the administrative record, and it would need to be very clear. But Patrick probably could do that from the AICP code, but when you're talking about from the municipal code, it's a little different.
Yeah, one of the challenges that he'll face as a member of the planning board is he's an officer. He will be getting a pecuniary benefit to his firm of that contract. And while there's an exemption for a benefit of an existing contract, so he might be able to scoot by technically in the balance of the year in which he is appointed. When it comes up for renewal, it seems like that would be barred interest. There would be no question that if he was on the village board, because they have the decision-making responsibility, that would be an impermissible contract and could null as a practical matter. In the connection with it being on the planning board, it certainly creates an appearance of impropriety in his role. For example, if the planning board was called upon to suggest or recommend what services, planning services who could be provided in the private sector to the board, he couldn't be recommending his own firm. That's sort of fundamentally a conflict. Probably couldn't do it under the AICP rules,
Right.
but he's certainly not likely to be able to do it under the general municipal law as well. So while it's an unfortunate circumstance, because here you have someone who wants to serve their community, you can't sort of have your cake and eat it too. That's the dilemma that he faces. And there may be, if the local ethics law had an absolute prohibition and clarified, sort of takes the general municipal law one step further with respect to that, that might also be another barrier. It's not likely to be it can't be less restrictive than the general municipal law, so it's more likely to be more of a prohibition that they'd have to face. But the point is, you gotta think about these things. It's not just, one of the things that sometimes you sort of get excited, would there be, I'd love to do that. You know, it's sort of a pride issue and you want to help your community. One of the first questions that I asked in the early 90s was whether our firm had any matters that were coming before the town of Clifton Park that I would have some nexus to if I was serving on the board, the ethics board. And in those days, we didn't. So it didn't seem to be an issue. If the question were to come up today, our firm is much more involved in planning and zoning matters in the town of Clifton Park. I probably couldn't do it. But that's one of the factors that you sort of have to think about. Okay?
All right. I think people are going to have opinions about this. So, social media is ubiquitous, right? We're not going to say it's good, it's bad, or ugly, or any of the above. It's ubiquitous. It exists. We're going to continue to use it, and we should be thinking about the best ways that we use it. And we should be thinking about what are our ethical and legal responsibilities when it comes to social media. Are they private? Are they subject to the Freedom of Information Law? How are emails between decision makers and consultants or engineers or applicants treated?
Let me follow up on some of the things Mark talked about this morning in the virtual meeting issue that occurs in email exchanges between individuals or on Facebook and exchanges that go back and forth. According to the Bob Freeman's open government folks, and Court of Appeals decisions as it affects email and what emails are, et cetera, they are all records if they are authored by or sent to or received by a governmental official in their capacity as a governmental official, irrespective of what device is used to send it or receive it. So if you're engaged in if a board member believes that because they have a private email and they are exchanging emails with another board member about a matter before the board, that is a public record. You can't destroy public records under certain other rules regarding both town law provisions and general municipal law provisions, except in accordance with standard archiving and other processes that are set out not by you but by some other entity. And so the sad fact of life is that much of what we do, whether it's deliberate or just inadvertent, is create records when we are public officials and officers or employees. We've been involved in several pieces of litigation against municipalities and between municipalities where the discovery of email exchanges that come about because people are careless and they use public message boards and other places where, and as Mark said, there are things you say in an email that you would never say in public, or you would not want to be seen as having said in public, and yet appear readily on these social media exchanges, et cetera. So that's the backdrop. There is very little ambiguity as to whether or not an email or a posting is a public record anymore. The case law is pretty clear about it, and if the case law isn't clear enough, the Committee on Open Government has made it very clear that is the rule. So when you look at their opinions online, you will see in virtually every one a standard set of paragraphs in the opinion letters that recite opinions of prior opinions, and all recite to the case law that has sort of upheld that. So just be aware of that.
And I think the other important part of that is on this, the third bullet on this slide, the latter half of that is that all the information on the internet is permanently public. So even Instagram, Twitter, all of that is Peter said, is ubiquitous. And when we were preparing for this, we thought this was very interesting because there's, we're all really connected, no matter the device, whether it's your phone, your home computer, or your iPad, or what have you. That's, there's a lot of information always exchanged, and so when hearing Mark talk about it this morning reinforced this piece for us. But it's a very sensitive area where I think everyone needs to be, highly aware of how they're using social media and email and exchanging information.
Does that ring true for texts between employees, officials?
Yes.
Well, what if it's on
Yes.
personal?
Doesn't matter.
Doesn't matter.
The question was, does that ring true for texts between employees or board members? And
Or if it's on your personal email.
Yeah.
And the answer is, those are public records. If you are an official and you are talking about official business that comes before you, whether or not you're on your government email, personal email, text, Facebook page, LinkedIn page, blog post, it doesn't matter. That is a public record. And part of it comes down to common sense, right? You never want to write anything down on any piece of paper or electronic media that you don't want printed on the front page of your local paper, right? That's kind of the general rule. If you don't want it published on the front page of your paper, don't write it down, because that's what's going to happen.
There's a corollary, and these are in probably some of the later slides, but there may be exemptions under FOIL for
Right.
Intra-agency communications, but they're still a record, and ultimately a court will decide whether if it gets to that level, will decide, or the agency's appeals officer will decide whether or not a request for that document meets one of the exemptions or not. You, the individual who may be the author of at least half of that communication, doesn't get to decide that. But you do have an obligation. For example, if a FOIL request comes into a municipality for all communications, correspondence, et cetera, on a particular application, that would fall within the responsibilities of the community to report that it's collected. Whether it has to be disclosed is a
different
separate
story,
question.
right.
But it is part of the record, believe it or not. And so again, it's this slippery slope of the nature of this new manner of communication that you need to be aware of.
So, did you have to maintain those for some period of time, and people, they trash their old computers, you get rid of your phone, if there was, somebody remembers they sent you a text and you don't have that anymore, is there an obligation as officers for us to maintain that for a certain period of time?
Technically, you would be required to provide it to your town clerk or planning board clerk as a record of communication. I mean, yeah, I mean, if you were to engage in and there's no guidance that I'm aware of that gets into this granular level of detail of what the responsibility is. So let me just preface that. I'm not that I've read a case that says this is exactly how you have to deal with it. This is my opinion as to how you probably should have to deal with it if it's occurring, which is you need to recognize that it's a record of communication on a matter. It's why Mark in part said, talk about the applications at a meeting or at workshops and all the rest. Don't have private conversations about it, because in our new world, this would be, you would have an obligation. And if you destroyed it or deleted it intentionally or otherwise, then there's a separate question about whether you are complying with administrative record keeping under municipal law. Who wants that headache?
So you'd be better off just to print it and give it to the
Yes.
planning board clerk?
Yes.
I think it goes to Mark's example of, running into somebody in the grocery store, and then you as a board member would go back and say, first of all, you'd say, please submit this and please come to the meeting and all
Yeah.
those things. And then you'd go back and say, I've had this communication with such and such on this application, and I'd like to report that to the board.
And it comes back,
Yeah.
and I was just saying, it comes back to why is that so important? And one of the reasons that's so important is because we want the public to believe, and believe rightfully so, that their applications are being debated on the merits, and that there's nothing happening behind closed doors that they're not aware of and that the public is not aware of. I mean, it's a pretty fundamental thing, right? So instead of the back room with cigars, it's the text or something else. And I think that's the reason for it. And so you can get to whether it's good faith or bad faith, whether you're doing it on purpose or not, but that's the reason. It's that, this should really be a public, transparent process that treats everybody the same and out in the open.
Yeah, while there's a question of, how and when does the open meetings law apply to that when it's less than a quorum? That's a question. Obviously, if you have a 7-member board and you have 4 people on the email exchange, you have an open meetings law problem as well. And so, but what if it's only 3 of the 7 that are exchanging emails? Again, you have a record issue with respect to the under FOIL that may be different than your open meetings law violations, but they're both statutes that you need to be aware of, that one doesn't necessarily diminish the other.
There's a question in the back first, and then
So under what circumstances can you do the interagency communication not subject to FOIL? And who can actually initiate that email exchange? Does the attorney have to initiate it, or can a planning board member initiate it, or a consultant? Could you expand on interagency communications not subject to FOIL?
Well, in this case, it would, I'm sorry, the question is, I guess the methodology for initiating an interagency or intra-agency communication. What's the process for how you do that, and whether do you need to go to the attorney or not? This isn't the issue is why. First question: why are you communicating in this fashion? If it's just to obtain factual information about the application or its status or something like that, that is, in my judgment, that's an intra-agency that doesn't decide anything. You're not deliberating for something like that. So it's probably going to be just a request for information, back and forth or clarification of some piece of information. That's done routinely. It's done, it can be done, it probably be done every day that if you're lucky enough to have a staff planner available to you, a board member comes in, knows an application is coming up the next meeting, and you get clarification about some information. That doesn't have to be recorded. If it's recorded in some fashion, if there's an exchange of emails or memos or something on that, then it's a record, but it's probably entitled to an intra-agency exemption. Because it's not intended to be public, it's just back and forth under that exemption. When it gets beyond that, when it becomes starting to become deliberative, that's a point where there's certainly a fair question of, wait a minute, is this an appropriate conversation to be had other than at a public meeting? Because you don't want to be accused of having pre-decided things in a cabal. That undermines the public deliberative process about your meetings. But does that answer it a little bit for you, or?
And there is an open meeting session at 2:30, by the way, which is, I would encourage you to go to. But it's a tricky subject. I think there was a question here, a comment here first.
Yeah, I think you answered a lot of my question. We recently had our planning board staff set up a official email for everybody who's on the planning board. So now we're starting to use that as a group. So now we're sending group emails, so everybody gets the email. But typically it's not deliberative in nature. So it's the questions like, what comments do you have on the minutes to try to update those, et cetera.
Right, and that's all part of an administrative record, okay? So, and that's a good thing. That's a good practice, by the way, for those of you who may not have heard, but having an official municipal email address for board members is a good thing. It avoids the inadvertent exchange of outside of the record, and you then have the municipality has the record where it belongs. But that is a good practice.
There's a question over here. Oh, question here.
When Mark was talking about if people come in and ask you for information, you could do, what kicks in a FOIA request versus just handing somebody information? I've had I come in, I want to say X, Y, Z. What makes the difference?
The question is whether, when someone is seeking a FOIL request of some kind, is there any requirement that sort of triggers a need for a formal request versus just an oral request? The answer is none. I mean, the municipalities basically have carte blanche as to what process they want to employ for seeking documents and access to public records. It can be done. Some have as Mark suggested, a routine. You have to fill out this form, and we'll get to it when we get to it, and et cetera. Others are, what is it that you need? And if someone's available to look quickly, and they'll supply a copy, probably without charge in most cases. Sometimes if it's more than 4 pages, they'll charge something, but it's much more informal in the real world, unless the size of the municipality or the size of the request or the record that they're looking for is large. The other trick in today's world is, again, where for municipalities that have websites, is they post right on the website in all of the correspondence, the application, et cetera, and so you can just download it if you assuming you have access to a computer.
And that helps take away the burden of the staff that maintain those records, right? It's just, instead of everyone coming in and asking for it, just put it out there. I mean, this notion that there is this long-standing notion that these are like, secret. If someone submitted an application, and I'm not going to tell you what's in that application, come to the meeting and listen. It's like, no. They submitted a public application. That is a public document. There's no reason not to put it up online. It instills confidence, and it creates less work for the municipality and less ethical issues.
How many municipalities out there do what Peter just described? So not that many, and if you're thinking of it, I live in Saratoga Springs, and Saratoga Springs got a grant, I believe it was a SARA grant, to revamped their website, and every application goes online, and then there's a hyperlink. Every agenda goes online, sorry. For every agenda item, there's a hyperlink to the application. The seeker letters, the seeker forms, the site plan drawings, everything imaginable, any sketches that an architect might submit is all online. And so for every committee, planning board, zoning board, city council, design review, et cetera, there's even a complete streets committee. All of that is online. It's very transparent, and I love it. As a planner, you know, I can geek out and kind of look at the agendas and, you know, Sunday mornings. But if you're thinking of it, take a look at it, call the city of Saratoga Springs to figure out how, there was a grant that got it funded, but it's a very great way to get, you know, the information
And
out.
it's capital intensive to set up, right?
Yeah.
There's a big upfront cost, right? No doubt about it.
Yes, sir.
If a planning board has an item for, like, for site plan approval, and like to expand the business, and the planning board members might have business interests with vendors that do business with that business, it would seem that at the very least they should be disclosing that, but should they even be deliberating and voting on that if, like, they're vendors that, you know, do business with the businesses expanding, or voting for the board?
Well, it really depends on, you know, facts with respect to that. The disclosure is fairly routine. If there is a likelihood of a connection between the application before and a board member and going on. But I think the word the courts use is you don't speculate about what future activities are going to occur in that circumstance. And if you have to start speculating as opposed to, it's probable, or this is the only person in town who could supply X or Y, then recusal would be the appropriate step for the individual. That's a, if local codes provide more guidance on some of that, there may be, obviously that's important to look at. But there is, at least in the cases that I have seen and the opinions that I've seen, it's less black and white than your question is suggesting. It's very much fact specific.
So I'm sorry.
I gotta finish this.
Please.
In my head. So if using our private emails, okay, that we would get information without opinion, just a fact to say there was somebody who had to get Adirondack Park approval, and they were gonna send that to us in advance of the meeting, we get our agenda, would we get, if that information came, we just said, here, this came from the APA regarding the such and such project, blah, blah, is that stuff, I mean, it's entered into the, presented at the meeting and all part of the record, that's stuff that I have to not be worried about keeping.
So the question is, if you are receiving agendas, minutes from previous meeting, and just general information on the project in your personal email, but it's also at the meeting, right? So it is a matter of public record because it's printed or it's provided at the actual meeting. Do you have to keep the information in your private email? Is that right?
I think the answer is if it's coming from the town, how you get it is also important. If there is a sent by the clerk of the planning board or whoever, the ZBA, that's enough. That's the record.
The record exists.
The record exists. So your receipt of it is less important at that point in time. It's just that you need, the concern I had on the earlier questions was nobody's treating it as a record because it's between individuals on their private emails.
I understand the part about
Yeah.
discussing.
Yeah.
It's back to board, the information.
No, as long as there is a sent provision of it, you wouldn't have a similar obligation to maintain. Unless the code says unless the local code says, you know, officers and employees are to keep all of their emails. And you may find that in the not too distant future. Peter, you?
Yeah, we have just a few more minutes left, so you want to do a special?
Yeah, we have about 10 more minutes, so I think we hit social media
Yeah.
pretty good. We're gonna,
Careful when you hit the send button.
yeah, we're gonna move on to special treatment, the star, for those following along at home. I don't know who's,
Go ahead.
all right, so, Susan is a zoning board member for the town of Worcester. Worcester? I don't know. Yeah, I don't know how we pronounce it. I hoped I made this up, the name.
There is a Worcester.
There is a Worcester in Ohio, yeah. A homeowner requests a special use permit to repair cars in his existing garage in a single-family neighborhood. Despite opposition, Susan votes to approve the permit with limits on the number of cars, and the permit's approved. Shortly thereafter, Susan asks the garage owner if she can store her antique car in the garage, and she'll pay. So, despite Susan paying, she voted for this expansion. It was approved. Her colleagues on the board approved it. There's no evidence that there was kind of a quid pro quo. You vote for this, you'll get it. And so the question is, has Susan received a special advantage? It's very close to whether or not she did. If there was no other garage in town, the AICP code probably says, okay, but you should probably let your board members and the public know. If there are other garages in town, I think the AICP Code of Ethics would say, no, you can't do that because maybe you were thinking about it when you approved it. And from the GML provision, it's a little silent, but
Yeah,
the
it's
local
a-
ethics code.
Yeah, the example of one of the local ethics codes that was in the materials would suggest you couldn't do it.
Right.
Because you're taking advantage of something that had come before you expressly. It's illogical in one way of looking at it, but it's this avoiding the appearance of impropriety. And that's for lawyers, that's a, magic, code of responsibility, issue. Even the appearance is a potential problem. It has not generally been applied, but in today's transparent world, an expectation of that, you look at the code of professional planners, you look at the codes that are applicable to lawyers, you look at some of the local codes that have a much higher aspirational behavior by individuals who serve in public service. You can get caught up in that, and all of a sudden, the standards, the community standards, are now different. And what could have been done routinely without anybody batting an eye 20, 30, 40 years ago, in today's world, no, people say, no, you shouldn't be doing that.
And it doesn't mean you can't patronize a business in your community that has come before your board, because otherwise you couldn't live in your community, right? I mean, we understand that makes sense. Can you go to the restaurant that you got site plan approval for, and they got to build the fence that no one else wanted? Yes, you can go to that restaurant. You're probably not seeking a special advantage. If they give you a free bottle of wine, yes, you probably took a special advantage. That's a problem. So at some point, there's this public accommodation issue, right? If this was a 15-car garage, then sure, Catherine can be one of 15. But this didn't sound like it. This sounded like 1 or 2 bays, and she gets to store her car there. If it doesn't pass a smell test, if you don't want it printed on the front page of your paper, it's probably not the thing to do, because it's not instilling confidence in the public that you made your decision for the public interest and not your private interest.
But in the question back to Dan is that in the issue of transparency, what if during the deliberations on the board, she says, well, I understand what he's doing, and I agree with the special provisions that we're putting on it because it's a special use permit and the limit of cars, and I get that because I have an antique car, and I may someday want to do that. I mean, what if you bring transparency to the deliberations on the board?
Well, she probably would have to then recuse herself.
Okay.
Right, associated
It's
with
like,
it,
it's
yeah.
kind of a snowball.
Right.
I mean, we had last year, it was just finally decided that we had a special use permit approved by a ZBA for a major hotel complex in the Central Catskills, and the opponents that sued multiple times on every approval that was granted and lost, raised at the local level that the chairman of the ZBA back in 2010 was the last time he did it, had cut lumber on the property that used to be part of the project, but that it was subsequently sold to New York State. And that because he had logged it, he should be recused from making a decision on the current project because of some connection with the applicant. The Supreme Court said, sort of, you could see the judge screwing his eyes up and saying, yeah, but that's he had logged that property for 30 years for whoever the owner was at the time, and you're saying that he's now making a decision about that past action. No, it doesn't make any sense. The Appellate Division, Third Department dismissed it even more summarily on the grounds that there was no, it was nothing he even affirmatively had to disclose, let alone that, because it had nothing to do with the application that was pending before it. It may have been something to do with the applicant, a member of the applicant that had it in the past, but it had no connection with what the board itself was being asked to do. So I just tell you that it doesn't prevent somebody from bringing in action, but the courts are going to look at the specific facts and whether there's something that triggers in their mind some closeness, a nexus is the legal expression, between the activity that is giving rise to the concern of a conflict. It has to be real before the courts will really get involved, and you need to but you need to have your antenna out. That's the message. The real message here is that if at a minimum disclose, and if it appears that someone believes that your decision is going to be influenced, then you recuse yourself from doing it. Yes, sir.
If you choose to recuse yourself, state that prior to the discussion about it, and do you leave the table if you happen to be a member?
Good question. The question is, if you are going to recuse yourself, do you avoid participating in any discussion, and do you have to remove yourself from the room? It is always a good practice to avoid involving yourselves in a discussion if you feel that you're going to be recusing yourself. You shouldn't be deliberating and just avoid making the decision. And there are court decisions that say the proper process is to recuse yourself, notice, disclose it, recuse yourself from any participation in the deliberations. You don't have to leave the room, but it's not a bad practice to do, because from the public's perspective, you're not rolling your eyes, you're not participating in nonverbal ways in the decision making or in the discussion, and being human, it's sometimes hard to keep a straight face on something
In the best of circumstances.
Yeah, in the best of circumstances. But if you have an interest in it, I can assure you, someone will have a video of you on their phone, and that's what today's world is like. So yes, that's the better practice.
And this would be a good item to codify in your rules of procedure, right?
Yes.
That way it's really evident and really clear how everyone should act. You should recuse yourself, you should state it, you should refrain from the discussion and leave the dais at the very minimum. And that's just a really good practice. I think we have like 1 or 2 minutes, so if anyone has any other questions or comments or situations you want to discuss.
I do have one question, Dan. In section 809, rules of disclosure and applications, is there a boilerplate form that you could modify for your town or your board for that purpose?
There are, I'm not sure I've seen a form. There are, in the ethics, codes of ethics, there are examples, probably. I can look, I'm happy to look to see what we've got around on that. But there may be examples in local codes. Yes, sir.
If a planning board member is also a member of a community advocacy group that appears before the planning board, often a
The question is, a board member who is also a member of an advocacy group that appears before the board, should you disclose that involvement? The answer is yes, but if you're a decision maker, and it's one thing to be sort of a member of the organization. If you have an officer position for the organization, in my judgment, you need to recuse yourself from that involvement. What happens is, we faced this once. There was an administrative law judge who was a member of one of the, one of thousands of members of an advocacy group, and we had questions about seeking his removal as the decision maker, representing an applicant, just because we couldn't tell at what point his head would be in the advocacy mode for this group that he had participated in versus his obligations to be fair on the record. So it creates this appearance issue for the decision maker.
Of not prejudging an application, right? I mean,
Right.
that's kind of the critical piece, is that you're not prejudging the application.
Yeah, the greater the stridency of the organization before the board would be a factor. If they basically, look, we think you ought to consider the following things, but they're not saying, deny this or approve this or whatever the position is, that would, in my view, enter into your judgment about whether you need to recuse yourself. But I would disclose it. Last thing you want is somebody, and it will always come either in an Article 78 petition or just before you're about to vote, somebody will come forward and say, do you know that? This person is. And you have an embarrassing circumstance at that point and a problematic one for the board to decide. So.
All right, well, I think we hit our time limit. Thank you for putting up with the technical difficulties and content.